Good morning, everybody. Welcome to the Courtroom Files Live. We're going to go ahead and start off our morning in Judge McNally's courtroom.
Okay, I'm good. No, thank you very much. You have a good day.
You're welcome. Okay, thank you.
Justin Allen Thomas, 24W721843. I need Mr. Strong. Good morning, Mr. Strong. How are you? Mr. Strong. Good morning, Mr. Thomas. Your name? You have to, I don't know why we're not getting you. Mr. Strong, are you out there? I need Mr. Collins here. Mr. Collins. Mr. Strong.
Ready, Judge.
All right, Mr. Strong, give me 1 second here. Just wait 1 second there.
Yes,
All
Your
right,
Honor.
can you just stop walking, Mr. Strong? People against Justin Adam Thomas, 24W721843. Mr. Thomas, your name, sir. Mr. Thomas. I don't know why I'm not hearing him. Can you tell, Lisa?
No, I sent him a message, but he's not responding.
Mr. Thomas, you look like you're pretty relaxed there, which is a great thing, I suppose, but I need you close to the camera. I need you to make sure your volume's turned up, please. Your name, Mr. Thomas. I can't hear what he's saying.
Judge, I acknowledge that
Mr.
that is Justin Thomas.
Mr. Strong, your appearance.
Yes, Your Honor. Ronnie Strong appearing on behalf of Mr. Thomas.
I'm just going to go ahead. You guys want a month adjournment, so 30-day adjournment. We'll go ahead and adjourn it. We still don't have the competency report. Mr. Thomas is there. I hope, can you hear me, Mr. Thomas? If you can, give me a thumbs up, please. All right, so he can hear me. So they're awaiting report. Let's just put this over to May.
May 6th at 8:30. I'm sorry, Judge,
At
9:30. 9:30. It's going to move
At
to
9. I'm sorry.
This will move over to Judge Hessen.
So this will move over to Judge Hessen, Mr. Strong. So next time you come in front of her, come back here, it'll be in front of her, and it's going to be May 6th at 9:30, okay?
All right,
So-
sounds good, Judge.
Have a good day, Mr. Strong. Bring those sticks with you next time
Thank you,
when it's warm
Judge.
out, okay? Take care. Thank
Absolutely.
you. Where is,
Okay.
wait a minute. Who do I have here? Hang on 1 second. All right. I'm going to call the prosecutor in here on yours, Mr. Collins. People against Venetia Renee Bell, 24M710670. Good morning, Mr. Collins. How you doing today?
Good morning, Judge. Harold Collins, P56805, on behalf of Ms. Venetia Bell, who's present on the Zoom screen. State your name, correct?
Venetia Bell.
All right, so I've got where is that coming from?
Oh,
Does somebody have something? Is there?
she's gonna have to
You
mute.
call Shane.
I'll mute her and then she can unmute when she needs to speak.
All right, so, Mr. Muhammad, I need your name.
Good morning, Your Honor. Mohammed on behalf of the people.
Did you give us a police report? What is the reason? All right, so let me start out by saying this is no objection and no low plea. This would be a plea to use, which is a 1 year, use of cocaine, which is a 1 year, and operating with the presence of a controlled substance, which is a 1 year. And in return, and I want to just cover something with you guys. The 4 year possession of okay, you got use of cocaine. It's use of psilocybin, isn't it?
I'm fairly certain it was cocaine, Judge.
Can you tell me allegedly what this was, Mr. Collins? Allegedly?
Allegedly, it was cocaine, I believe, Judge. Ms. Bell, what do you say?
Your client's shaking. Hang on a second. Your client's shaking. Hang on, ma'am. Just wait. Your client's shaking her head no. And the allegation, the complaint, it falls under the cocaine, heroin, or another narcotic, but they specifically allege less than 25 grams of psilocybin. So it's mushrooms. It's not cocaine.
Well,
right. I think it was the catch-all, Judge, that we were going with.
I get it. But they wrote on the plea form cocaine, and I'm going to ask you to change that to psilocybin.
Okay, Judge. Okay, I'm going to review the report.
Okay. I need the police report. When you're sending these in for a no contest plea, please send me in the report, okay? I don't have it. You're gonna have to bring it in. Maybe it's stuck in this file somewhere. I'll let him look at that. Okay. What is the reason for the no contest plea?
So it came at the request of defense, and I was informed that due to the defendant being under the influence, she couldn't recall exactly.
Is that true, Mr. Collins? Yes, say no again.
Judge, at this time, I would just request to withdraw the plea because the defense is shaking her head no to almost everything, and so I just don't think it's appropriate. We can set this for a preliminary exam.
Wait a minute, slow down.
Mr. Muhammad, just take it easy, Judge. She was blacked out at the time. She was fine. You guys,
let's wait a minute. She's shaking her head. This is not comfortable for me right now. Just stop shaking your head, Ms. Bell. I'm going to let you talk to your lawyer in a breakout room. Mr. Muhammad's, listen. Just listen. Mr. Muhammad's going to look at the report. He's going to pull the report if it's going to be a no contest plea. I'll be happy to take it, but I want you to understand something, Mr. Muhammad, before you leave the courtroom. I've gone back and forth with the prosecutor's office about sobriety court. I want to make sure that this deal is not contingent. In other words, if she gets into sobriety court, the plea stands, obviously. If we're going to put her through a phase of bond conditions. If she doesn't comply, and I mean, especially if we don't think we can help her because she's not showing up, she's not taking it seriously, she's testing positive constantly, the team will meet. We're going to decide whether or not we're going to accept her. We want to accept her. But if we don't accept her, I want to make sure you're still good with this deal. I don't want to be having to say, well, it's contingent on her being accepted. And since you didn't accept her, Judge, we have to start over. I want to make sure none of that's part of this.
Correct, Judge. It isn't. And that's why I did check mark the recommendation.
Right. Now, I want you to understand, though, Ms. Bell, and I'm going to let you talk to your lawyer. If you don't make it into sobriety court when they've cut you this deal, you're likely to do some significant jail time in the beginning. So I only want you getting into this if you truly want to be in sobriety court. And I want to explain to you real quickly, in case you haven't had the opportunity, it's not for the weak-hearted here. We'll put you in a bond phase. You'll immediately start testing 2-3 times a week at your own expense. You'll immediately get into treatment. You'll immediately be placed on a SoberLink device, even though this involved drugs. And I don't know what the extent of your alcohol problem. You'll immediately start going AA, NA 3-4 times a week. You'll immediately start meeting with probation every other week. And you'll have to meet with me in the off weeks. It's not for the weary. This is not something I would recommend anybody do for a restricted license or to avoid jail or because they think it's better, because it's tough. And I don't want anybody coming in here thinking the program is just a little bit more than regular probation, because it's not. So I'm not discouraging you. I'd love to have you. I've enjoyed sobriety court. We've helped a lot of people turn their lives around, but this decision is personal to you. And it should only be made if you decide to go this route with the idea, I want to change my life. I'm not just looking to get through 2 years of probation. I want to change my life. I want to stop using drugs. I want to straighten out my life and get clean. So now you can unmute her. Do you understand everything I just said, Ms. Bell?
Yes.
All right, so I'm going to put you in a breakout room to speak to Mr. Collins. I'm going to put you in a breakout room to speak to Mr. Collins, and then Mr. Mo. Yeah.
Judge, if I may, I think the court has been fairly explicit in what the terms are. It's really, at this point, Ms. Bell, I believe, is willing to go forward, Judge.
That's fine. She was shaking her head no when you said she was blacked out. She was shaking her head no when everybody was saying cocaine instead of psilocybin. I'm still going to take a plea based on the use of the controlled substance in the complaint. I'm not going to pretend it's cocaine. So you guys can figure it out. I will be glad to take it. If you satisfy yourself, when you look at the report, you pull the report, you give it to us. If it's going to be a no contest plea, then I don't have a problem, but just indicate on the plea form it's psilocybin, not cocaine. There's a difference. You can take the file.
Okay.
All right, that's what I'll do.
They
I'm
are
not going to
within-
keep you, Mr. Collins. As soon as he comes back in with it, I'm going to get you out of here,
But
okay?
Judge, just to confirm, they are psilocybin and cocaine fall within the same schedule, so it's the same charge, correct?
I know that, but I'm
I'm
not going to
asking-
ask some, it's under the same statute, but it's still, your complaint alleges psilocybin. That's mushrooms. That's not cocaine. And I'm not trying to argue with anybody. I'm not going to ask anybody. I could just say use of a controlled substance and leave cocaine on there, but
No,
it's
I
not
was just asking a question.
No, it does. It's
Okay.
correct.
Okay.
But I'm going to ask her specifically what she consumed.
Okay,
Okay, used and what she used before she operated the vehicle.
I understand.
Thanks. Okay, real quick, Singh Bobander, 25M487802. And I will.
Okie dokie, real quick, welcome to the Courtroom Files Live. Happy April Fool's Day, if there is such a thing as a happy April Fool's Day. I'll be honest with you, it's my least favorite day on the calendar because, as I suppose the name implies, it just allows people to act like fools, and I don't know. But, you know, we work for ourselves here, so if we choose not to go out and interact with the world, we don't have to, so it's nice. I've got a rare donut this morning, which I rarely eat. I've got my official certified law junkie mug filled with some Earl Grey this morning, and I'm happy to enjoy some courtroom with all of you. So let's go back to Judge McNally.
He would like to hold a hearing, and I'm sorry
I got it. No problem. I understand. I've heard that from the state police. No problem. Don't worry about it. I get it. April 15th, Lisa?
Yes, 9:30.
At 9:30.
Can we do that by Zoom, Judge, or do you prefer us to be there?
I don't have a problem with that by Zoom. We don't have any paperwork that says we have to show up on formal hearings, right, Lisa? I mean, there's no notice.
No.
I don't have a problem by Zoom. We'll make it by Zoom.
All right,
That's a
thank you,
civil
Judge.
infraction. Have a good day. I'll see you then. Thank you. Thomas Rupp.
Well, Judge, I'm sorry, I
Right.
don't mean to interrupt. There's one other ticket that was scheduled for next week, and it's a case, they put the case forward. It's a it's a file number 25S11.
Wait a second.
You
Come
have
on,
it.
man.
Judge, I moved it to today's docket. You have it there.
Oh, well, he didn't bring it in. What?
Gas retransport.
And thank you for doing that, ma'am.
No problem. Just let me get the file here. What's the name of the defendant's name?
It's a company named Casri, CASRI Transport.
I need somebody to bring in cash retransport I need cash retransport.
Real quick, bottom left of the court feed there. I'm not sure that's court appropriate attire. I don't know. You tell me in the comments if you disagree, but I don't. This is the one downfall of Zoom court is everybody dresses inappropriately, in my opinion. But if we didn't have Zoom court, I suppose we wouldn't be able to do these videos and, watch along and learn about our system. But I don't know. That doesn't seem like appropriate attire to me.
All right, I got it. All right, people against cash retransport Inc. 25S118057.
Let's go ahead and switch over to Judge Fleischer's court. He just came online. I don't know if this is on purpose or if he's, just forgot to turn his camera on, but he is not on camera today. It's just the shot of the courtroom. So we'll watch along and see if that changes.
On March 24th, 2025 at 5:40 p.m., officers were flagged down by a business owner at 8920 Gulf Freeway. The owner of the business stated that the defendant did not have business to conduct in the location and wanted to have a trespass warning against him from that location. Officers made contact with the defendant, leading against the vehicle with the front driver door open. Officers observed the odor of marijuana emanating from the vehicle. Probable cause search was conducted and officers found an empty cigarette pack with pills, which based on the color and markings and the officer's training and experience believed to be Xanax. Officers weighed those to be 0.53 grams. The defendant did not have a prescription for the Xanax. The defendant stated he's the owner of the vehicle and he's the sole driver of the vehicle. The defendant stated he had just bought the vehicle but did not change the title to his name and he did not know anything about the pills.
Got it. Mr. Oliver, I'm going to find that there's sufficient probable cause to go forward with the case. You looked up his license, see if he has a valid license.
And I don't see a DL number on file.
If you do not have a Texas driver license and liability insurance, you're not allowed to drive. Do you understand? You will be signing an affidavit with me today promising you're not going to drive without either. If I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand? You're not to go back to the business that's listed in this place. You're not to consume alcohol or illegal drugs. I'm going to randomly test you. If I find that you have a drug or alcohol problem, I'm going to address it for you. And I promise you're not going to like the way that I do it. So do you understand? Mr. Alawar, do you have the ability to hire a lawyer?
No.
I'll have you, Deputy Miranda's going to give you an application. I'm going to have you fill it out. I need to know everything about you to see whether you qualify for an appointed lawyer. If you do, I'll provide you a lawyer today. Don't pick up any new cases. Otherwise, it's not going to go well for you. Do you understand? Okay, Deputy Miranda, do you mind? Thanks.
Judge, is that free for all bond conditions?
No, he's going to be monitored.
Victoria.
Did you get do you know who it is?
Yes, Judge.
Okay, so just no driving, no weapons, no alcohol, no drugs, random urinalysis.
Yes.
And no going back to this place.
Yes. All right, Judge, next is page 10. Gonzalez, come on up.
So real quick, I told you a couple of minutes ago that I had a donut, which I rarely have, and apparently the April Fool's joke on me is that donut is absolute garbage. It's horrible. God, I go and I pick something for myself that I rarely treat myself with because I try to eat well, and there you go. April Fools.
David Gonzalez. Yes, sir. David Gonzalez, you're charged with tampering with the government record. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 24th, 2025, officers were on patrol in East Alden Management District in Harris County, Texas. Officers conducted a traffic stop on a motor vehicle that failed to display a license plate. Upon approaching the motor vehicle, officers observed a temporary tag that expired on 10/29/2024. The defendant was identified by his APHIS mugshot and SPIN number. The defendant stated he knew the temp tag presented did not belong to the motor vehicle. Officers concluded that the defendant knowingly presented a record with his knowledge of the fault. Defendant did not have an ID on him. TCIC searched the tags, came back to a different motor vehicle. Officers discovered the vehicle was salvaged and should not be operated on a motor vehicle. The vehicle then shown on the vehicle was registered in South Carolina. Temporary tags that were displayed were for a vehicle registered in Texas.
Okay. Did you run his license? See if you have a license. Please.
That's eligible, Your Honor.
Mr. Gonzalez, you are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. You must maintain car insurance. If I find that you're driving, you don't have car insurance or you don't have a valid license, I will revoke your bond and put you in jail. Do you understand? Do you have the ability to hire lawyers, sir?
No.
Okay, I'll have you fill out an application to see whether you qualify for an appointed lawyer. I need to know everything about you and I'll take a look. We're going to have you sign documents here promising us you're not going to drive without a valid license and insurance. And after that, I'll take a look at your application. If you want to head on over to Deputy Miranda, he'll give it to you, sir.
That's going to be state's bond condition?
Yes, please.
Go ahead and sign for your reciprocals. All right, Judge, page 13, Ibarra, come on up.
You are Josue Ibarra. Yes, sir. Mr. Ibarra, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, sir.
Sit under 21, Your Honor.
Okay, is that all you have?
I mean, Your Honor, feelings on it is,
Yeah.
Officers were on 3/24/2025. Officers were on routine patrol with like witness. Witness stated to officers that he observed a defendant assaulting a female in a apartment complex. Witness told officers that the witness saw the defendant displaying a firearm towards the female. Officers located the defendant while the defendant was yelling at the female. Officers told the defendant to lay on the ground. Defendant stated he did not have any weapons on him. Officers conducted a pat down. Defendant felt a bulge in the defendant's ankle. Officers recognized this to be a firearm. Officers retrieved the handgun from the defendant. Female advised officers that she was not assaulted. NCIC, TCIC check revealed the firearm was reported stolen. Officers observed that the defendant was previously arrested, also previously dealt.
Did they take?
They took.
Okay. Mr. Ibarra, I'm going to find that there's no probable cause to go forward with the case. How old are you, sir?
18.
How much? How 18?
Yes, sir.
God forbid you have a weapon and you do something where you create irreparable damage, like use it in a situation. You need to be very careful in this life. You only have but one life. You have a gun and you use it and there's something wrong. Your life could change in a moment's notice. Do you understand?
Yes, sir.
Very careful. All right, just hang tight for me, will you? Please. Thanks.
All right, Judge, next is page 26 and 27. Scarborough, Alex?
Mr. Surovov,
Yes, sir.
you are charged with evading arrest or detention and driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Officers were dispatched to 300 Memorial City Way, Memorial City Mall, for a male detained on suspicion of driving while intoxicated. Defendant was observed by officers as well as several security officers driving erratically in the parking lot by failing to stop at a designated stop sign in that parking lot. The defendant was observed on security cameras stepping out of his gray BMW sedan, expose his genitalia, and urinate next to his rear driver's side tire. Officers made contact with the defendant and smelled the strong odor of alcohol, slurred speech, and observed 2 empty containers in the vehicle. Officers detained the defendant. Defendant was erratic.
Drinking while driving?
Containers in the car yard. Defendant was erratic once placed in the back of the patrol vehicle and continuously banged his head on the window. Defendant spit at a security officer, which made contact with that security officer's left cheek. Defendant lied drinking. Standard field sobriety tests were conducted. Following results: 4 of 6 HGN, 5 of 8 walking, 3 of 4 one-leg stand. As far as the evading goes, Your Honor, officers attempted to grasp the defendant in order to detain him while he was being detained, to try to put handcuffs on him. The defendant was able to slip out and evade it for approximately 100 feet before he was once again detained and placed in the handcuffs in the back of the car.
I'm going to find that there's sufficient probable cause to go forward in both of your cases. I am now taking away your privilege to drive. You are not allowed to drive whatsoever for any reason, and I don't give a rat's behind what your excuse is. If I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand? I am now sending you for a drug and alcohol test. I want to know what, if anything, is in your body. If you fail to take the test, if you fail to come back, I will issue a warrant for your arrest. You were to come back, and then we will continue on your bond conditions. If you have a problem with drugs or alcohol, you better address it, because if you don't, I'm going to do it for you, and I promise you're not going to like the way that I do it. Do you understand? As it stands now, you will get a scram device that I'm going to put on your ankle so I know that you're not consuming alcohol or anything else at any time. And I'm going to drug test you like crazy. At the first instance you use anything, I will make your bond so high, you'll have patches of hair falling out. Do you understand? Come up here, swear to us that you're not going to drive, and then we'll send you for a drug test, and then we'll have you come back. Vic, do you mind reaching out to the Mac for, please?
That was the last one for now. We're waiting on the interpreter for the plea.
Okay, since he's gone through most of his arraignments, let's go check in with Judge Middleton this morning. I gotta say again, though, I hope that Judge Fleischer isn't making a permanent choice by not being on camera here, but he's gotten really, really weird in the last few months with how he handles his live streams. I don't know if he's just taking a lot of heat or what, but it's like he's trying to find this weird middle ground between streaming but not ticking everybody off. And what I will tell you as somebody who's in the YouTube space, that does not exist. You always make people angry. I told you a few streams ago, I get death threats every day. I don't know why. It just happens. You're never going to make everybody happy. So you just need to do what you want to do. But that's just my opinion. Let's go look at Judge Middleton for a little while.
That's one reason. It happens often in a drinking driving case. Someone's driving a car, they hit a tree, they're intoxicated, they wake up in the hospital, they don't remember anything that happened. So they can't plead guilty because they don't remember it, but they'll plead no contest. They'll accept that a conviction would enter. The other rationale is if you injured someone and they could potentially sue you for damages, this would protect those facts from being used in a civil matter. So are you going to plead no contest to this charge?
Yes, sir.
Did anyone threaten you to get you to do that?
No,
Promise you anything?
no.
All right, well, let's take a look at the bond information sheet. Where's Hideaway Lane?
So my mom's driveway.
All right, where, that's in Sherman Township?
Yeah, it's Middale area.
All right. They get dispatched to a domestic assault. Your mother says her daughter had assaulted her inside the home. They have a domestic relationship as their mother and daughter. Butts has lived with Hartman until she was an adult. Butts assaulted Hartman during a heated argument. Butts tossed a child's water bottle at Hartman, striking her in the stomach, and additionally assaulted her in the residence. Butts grabbed her mother by the hair and slammed her head into the washer and dryer and the wall. She had a cut on her face and a bruised lip. Butts further assaulted Hartman when she bit Hartman on the left arm just above the elbow, which is already starting to form a bruise. When I arrived, Hartman stated she was bit when she was trying to get away and trying to keep Butts' 2-year-old daughter away from her while attempting to call 911. She claimed her mother attacked her first. All right, let's see what else we got here. Butts was then advised that she was under arrest for domestic violence, to which she attempted to jump back into the driver's seat of the vehicle and pull away from me during handcuffing. Butts was then forcibly removed from the vehicle driver's seat, where she continued to resist being taken into custody. Butts' actions forced me to take her to the ground for handcuffing, where she stopped resisting. That's a sufficient factual basis for domestic violence and attempt R&O. That's the bond information sheet that was prepared by Officer Van Dyken, who investigated this and made the arrest. Where are you living now?
At the 504 East Hatch Street.
All right, is your mother's not there?
No,
Whose house is that? That's your, all right, so you're not at Hideaway, you're at 50, you're in Sturgis, okay. Are you employed?
no, not currently.
Is your daughter with you or your mother?
Me.
What kind of work have you done?
Healthcare work.
All right, let's set this for sentencing. I'm gonna need a police report and victim input.
Do we need to confirm if the prosecutor has any objection to treatment under the Holmes Act?
I thought that was part of the plea agreement, but we'll see.
You have no objection.
Now it's up to me ultimately. It's not a guarantee. It's, but we'll see. Had you been drinking when this all went down?
No,
Were you on any medication?
I take medication every day because I go to my counselor every 2 weeks usually. I have Lexapro and Ativan, and then we're trying to mix up other things with it, trying to figure out how to stabilize everything. So I've been on and off on different type of medications.
Wednesday, April 30th looked blank, but it's blank because I've got a mock trial that day. How about Monday, April 28th at 10:30?
That's okay for me.
Does that work for you too?
Yeah.
When I get the police report, I want you to share with your lawyer your counseling and treatment information. So I can review that as well. I want to get some input from the officer and your mother. All right, stay in contact with your lawyer, get that information, and we'll be prepared to do the sentencing at that time.
I think you're asking for her to try to get me the counseling information.
Well, yeah, if she wants me to know, I mean, she's on medication, she's saying she's getting treatment, I'd like to know about it. Before I do the sentence. I didn't ask for a pre-sentence. I'm just gonna get the information.
You know, if you want to wait for me when I'm done here, but it's up to you. You gotta go, I'll call you. Yeah.
Let's go back to Judge McNally, which looks like he's still dealing with Venetia Bell, the one with the questionable attire, who, as soon as I said something, adjusted her camera angle. Let's see what's going on there.
This isn't like, let's do this, this is easier today, and it's not going to be bad tomorrow. I'm not trying to talk you out of it. When we accept you into sobriety court, the grant pays for your SoberLink device. Unmute yourself, please, or mute yourself. It pays for the SoberLink. We can assist with treatment. It pays for testing. But until then, we cannot use grant funds when you're not in the program. And you're not in the program until we accept you into the program. But I'm just telling you, Mr. Collins, I want to put the brakes on here. And I'm just not sure she's gonna, I mean, when I can't even get her here today, she doesn't have a car, she does. How is she ever going to get through sobriety court?
Judge, were you saying tomorrow was the first day to be there at 7:30 or 3 p.m. tomorrow?
Tomorrow for a status review hearing.
Okay, so tomorrow, Miss Bell, not today. They're not requiring.
Well, no, I wanted her to come in and meet with probation and get her SoberLink today.
Okay.
I mean, if somebody wants, you know, ma'am, if you want to think I'm being unreasonable, that's okay. It's all right. I'm okay with that. I'm just not taking you to the program if you can't do these things. I'm telling you. I'm not.
She just has some restrictions. I think her license, she needs her license freed up so she can get there. She wants to take advantage.
she's going to end up with her vehicle immobilized before I stop this for 90 days because I have to by law. Let me just double check something. Who's Thomas Irwine? Ma'am? Ma'am?
Is that the gentleman whose car I was driving?
That's what our records reflect.
Okay, so he was my mechanic. My car was in the shop at the time. And he let me use his car.
Well, I can't immobilize your vehicle. I can't order immobilization, but
I don't have a car.
I know. I got it. I heard it. You said it. I just wondered where the car was now that you were driving. If it was totaled fine. I didn't know
No,
if it was
it's in my
your-
driveway broke down. The timing chain
All
broke
right,
down.
so have you, let me ask you this. Did you give consideration to how you're going to comply with these requirements? I mean, I don't.
I'm terrified that I don't know. Like I've been doing it for Wyandotte the best to my ability, and I'm doing okay with it. I fear that the cost is what's going to get me.
Well, I'm not gonna lie, the cost is expensive while you're in bond phase. And you're gonna get hit with sobriety court fees and probation fees, but you got a problem. And this should be on the top of your priority list.
I mean, I've been sober
Ma'am?
for a couple of months now.
She is testing twice a week, Judge, already.
Yeah, I know, but I don't think she's gonna make it based on what she's telling me. I mean,
I've never not made it.
Ms. Bell, are you willing to comply with the dictates of the program?
I'd love to have you. I'd love to have you. Time out. Time out. Mute yourself. Love to have you in the program. I wouldn't run a sobriety court. I started this in 2008. I spent a whole year trying to get the ducks in a row. I'm not going to try to discourage you, but when I got somebody saying they don't have a car and they can't get here today, and oh my God, getting here tomorrow, it sounds like, and getting anywhere. Ma'am, I don't want to debate any of this. It doesn't, I don't know what else to tell you. The requirements are the requirements. If you can make it, great. If you can't, tell me now, because the penalty will be a lot less than if we start investing all kinds of resources and I find that you signed up for a marathon and only walked to the end of the block. Now, I'm not saying you're going to do that. You might be the best probationer we've ever had. But the fact that you can't get here from about 4 miles, 5 miles away today tells me we got a problem. I mean, I don't know how you're going to get here at 7:30 in the morning or 3 in the afternoon. I don't know how you're going to get to testing all these times. Unmute. Tell me what you're thinking. I'm not.
I was prepared to walk today. When Mr. Collins said we could join via Zoom, I will walk if I have to. It is a 2-hour walk. And if I got to walk, I'll walk.
Wait a second. Jeez. How are you going to get to all these obligations? You're going to have to be going somewhere listen to me. You're going to have to be going somewhere 5 days a week. Listen, please. I got all kinds of people in here. I don't want to, I feel bad that you're crying. I'm not trying to make you cry, but I cannot solve these problems for you. I cannot solve the ride issue for you. And I need to make sure that you're ready to go. If you're not, fine, we'll let you withdraw the plea and we'll go to the exam next week and maybe you can take your chances. I don't know what to tell you. Stop crying, please. You should have thought about a lot of this before. Stop crying, please. To say that you're going to walk 5 times a week that takes you 2 hours, the testing facility's right down the street, that seems like a bit of a difficult task. That's 10 hours to get at least 10 hours. And
I'm
that
the sole
doesn't include
provider
all
for
the,
my daughter. I have no choice. I have to. I'm the only caregiver for my child.
Ms. Bell, if you want to do it, I'm going to let you do it. I'm just forewarning you. If you don't make it through, it's not going to be pretty.
I'm
You do
afraid I
whatever you
can't
want to do,
afford
but I
it.
can. Counsel, I don't know what to do with her. I cannot solve these problems for her. I'm not going to give her the money myself, and I'm not going to go pick her up. What are we doing here? I mean, I don't. Okay, you can't afford it, and you got to walk to. I don't know what to tell you. You're giving me both sides of the coin here. This isn't like. There's no middle of the road with this. There's no middle of the road. You're either 100% compliant or you're not going to make it. I'm just telling you. Now, do we expect and understand that people are going to have relapses? Yes. Yes.
No, I don't. I'm not going to. That's not my fear. My fear is not being able to afford to get there.
I don't know what to tell you. I cannot solve these problems. Maybe you need to go to the circuit court and take your chances. I don't know. I don't know. I mean, that's for you and Mr. Collins to have talked about. I'm not talking you into it. I'm not talking you out of it. I just want you to understand what the program's about. But this stuff about, I don't know what to tell you. I don't have any answers for you. I cannot solve everybody's problems that have nothing to do with me and my ability to try to rehabilitate you, except for the fact that you can't get here.
I was drugged that night.
Ma'am.
I was drugged by somebody else.
I got all these people here. This is for you and your lawyer to talk about. I'm not going to engage in a debate here. I mean, I don't know what you want to argue with me about. I'm telling you what the program is. I'm telling you what the requirements are. I'm telling you it's not going to be an excuse that you couldn't get a ride. I'm going to tell you right now, if you tell me, Judge, I just don't have the money to go test, you're not going to make it. Now, this is only for a 5-week period. Counsel, I don't really know what to do with her at this point.
You said for 5 weeks. What's for a 5-week period?
The bond phase. That's how long it takes to get through the bond phase. I would give you a sentencing date in 5 weeks. You would come in here today. They'd tell you you need to go to AA. They're going to set the bond conditions for you. We're going to get you out of SoberLink. You're going to be testing 3 times a week. You're going to be immediately in treatment. You're going to be going to AA 4 times a week. And all that's going to be at your expense. Now, when we get you through the bond phase, then I can use grant funds, but I can't legally use grant funds in the bond phase. And I'll be happy to tell you that as long as you test every time and you test negative every time after you're accepted into the program, we're going to pay for your testing through the whole program for 2 years. As long as you blow into your SoberLink every day 5 times and you're negative every day 5 times, we're going to pay for your Sober.
I don't even drink.
Ma'am, with all due respect, at this point, you're agitating me. You're going to be on a SoberLink device, okay? Period. Plain simple. I'm not treating you better.
Okay.
Now, I don't care if you do the program or not at this point. I'd like to have
the SoberLink doesn't concern me. That's the easy part.
Ma'am.
I'm not concerned about it. I'm okay with that.
Ma'am. Counsel, I'm putting you in a breakout room with her. And you guys can decide. I'm not engaging in this colloquy anymore here. I've got a lot of work to do today. I got a lot of people, and I don't want to debate this or talk about our inability to afford it or get here. I can't do more than I'm doing. I mean, I don't know what else to tell you. She seems to want to argue with me about all this. I'm not lifting a SoberLink device because she tells me she doesn't drink. So I can't hear a word you're saying, Mr. Collins.
Judge, she's not asking to have that removed or not tested on it. Ms. Bell, are you willing to deal with the dictates of the program? Yes or no?
She went to a breakout room.
Okay. Thank you, Lisa.
Go talk to her.
Okay.
Go talk to her. Thank you. Amaya Marie Rosario, 25M497.
Okie dokie, this is a good time to catch our breath there. Put a 1 in the chat if you want me to look at making a full video on that whole interaction later today. So we caught the initial part of it, where she kind of revealed how poorly she was dressed, and they were talking through some stuff. And then in this piece that we caught here, it's obvious that she wants to get into sobriety court. So seems like there's a full story to tell there, and I'm willing to tell it if you want it. Just let me know. We were looking at Judge Fleischer earlier, and he just has the one camera. But I did a little digging around in some other areas, and something was brought to my attention that's true. If you look at the quality of the feed, it's better than it's ever been. So that's a new camera. And it's possible that they're upgrading their cameras and Judge's camera just hasn't been installed yet or something like that. So I'm hoping again that this no Judge Fleischer on camera isn't a permanent thing, but we shall see. So let's address Mark Mack's question about what everybody thinks of First Amendment auditors. B. Davis chimed in, while some are antagonistic, centric, it's protected, period. Yeah, it is protected. I think, honestly, though, in my personal opinion, a lot of these First Amendment auditors that you see out on the YouTubes, it's all just searching for clicks. It's a lot of times it feels like the legal equivalent of the show Jackass to me, where people are doing stunts to get to that moment that shocks people. And it feels like that's what a lot of that is. Now, I've told you before that I don't get political on this channel. This isn't a political thing. This is a philosophical thing for me. I am a staunch defender of the Constitution. I believe that America has the best system out there, despite how broken it can be. I still haven't seen anybody that does it better. Are there areas we can improve? Sure. But, you know, I show me something better with the diverse cultures that we have. I don't see it. There are certain countries that run smoother, perhaps, but again, it's a very centric culture that we just don't have here. So I think it works for what we have. But just because you have rights doesn't necessarily mean that it's appropriate for you to get out there and every day prove your point 50 different ways and shout it to everybody about how this one thing is being interfered with, and therefore the person who's interfering with you is like the worst thing in the world, or I don't know. Again, it feels like a lot of the content that comes from the First Amendment auditor people, well, I don't disagree that what they're trying to do should be protected. Do they really even need to be doing it? It's searching for content, and it's shock value kind of content. It's stuff that gets clicks, which, you know, as a YouTube creator, I get that from a certain standpoint, but I don't think it makes any sense to damage society and damage culture to make your point. And I feel like a lot of this is damaging because it just continues to foment the hate and the divisiveness that we have in our country. And I don't know that it necessarily serves the purpose that they say they want it to serve. Now, this is a blanket statement. Obviously, it doesn't apply to everybody. You know, there are some people that do good work. There are some people that do bad work. I just don't know that a lot of it makes sense. I mean, there are better ways, perhaps, to make the point that you have rights than to go out there and create a scenario that essentially just gets you clicks and views. Just my view. But again, let me know what you think in the comments. Reasonable minds can disagree on everything. And if you've figured anything out about this channel, I hope that you've figured out that we're just trying to be reasonable minds here. But, you know, you let me know. Well, I've got you away from the courtroom real quick. One other thing I would like to cover with you. Yesterday, we made a fairly significant change on this channel in the fact that our stated goal is to provide as much value as we can. And part of that is through channel memberships. We had 3 different tiers. Yesterday, we took away 2 of those tiers. We kept the least expensive one, and we put all the features into that least expensive membership. It's $2.99 a month, and that $2.99 a month gets you loyalty badges. It gets you emojis that you can use in the chats. I do place a priority on responding to channel members in the comments. It gives you behind the scenes access. We've started posting photos. Actually, I got a bunch of them I got to post yet, but photos of what we do behind the scenes. A lot more of co-host Ellie and the animal crew that we have here at the Courtroom Files compound. We do have members only shorts and videos. And here's the biggest thing in my mind. Channel members get a 20% off all the time at the Courtroom Files store. And that alone pays for itself if there's any merch that you want. Just this certifiable law junkie mug, which is what we named the membership, as a certifiable law junkie. If you just get this and you use that discount that you get with the membership, it paid for that month's membership. So if you want to support the channel and you want to be a help in what we do here, you're certainly not obligated, but if you want to, this is the least expensive way to do it. And if a couple hundred people become members, it covers the expenses here and helps us move forward. So I put it out there for you because I think it's one of the best values out there in the LawTube community if you want to support what we do here. Again, you're not obligated, but if you're interested, please visit the channel page and join. If you're on an Apple device, you can't do it through the app unless they've changed something that I'm not aware of. You need to do it on the web page. But other than that, all right, let's go to who's good right now. Let's go to Judge Middleton. He's got somebody in the jail. It looks like that he's talking to.
Do you have a guardian or anything?
Yes, I do.
Who's your guardian?
Jody.
Jody?
Yeah. Jody.
All right.
Clark.
It's guardianship alternative out of Georgia.
Yes, all right. You had that accident when you were a little girl.
Yeah.
And it's affected the whole rest of your life. And but I want to make sure that we've got someplace for you to go. Let's look at the calendar again. Today's April 1st. Well, Paul, I think I can cram this into next Wednesday, April 9th at 10:30. Are you available then?
As long as the trial that is scheduled, I guess, with Judge Pattison, as long as I'm not in the middle of that trial, I guess, but.
Well, we'll fit it in somewhere during that day if we need to.
Okay.
At 10:30. Maybe we do it later that day. I'm gonna need some help from Pivotal and maybe your guardian, Mr. Gibson. I'm gonna direct you to contact your guardian. Miss Shanna, Guardians Alternative, does a very nice job. They got the Liberty Bell Award several years ago. I don't know what to do with you, Ms. York. I don't want to just tell you, go and sin no more. You don't have any money. You got anger issues. You're more of a danger to yourself than anybody else, but your mom alleged that you pulled her hair out and your sister got pop poured all over, and then you fought with the cops.
I pulled my sister's hair, not my mom.
Okay. I'll ask Pivotal for some help. All right, sentencing is set for April 9th at 10:30. I'll see you at that time, Ms. York. Okay. You're good to go. Need to hold on to that file. So that's, I asked them to bring up Vergowan, who I was told was a plea. James Jones would be a waiver, and we don't know what we're doing with Travis Yoder. What is the plea offer in Vergowan? Oh, he's the guy that left.
Right.
He gets a special bench warrant with a 48-hour hold. Chad Earl Vergowan, 25470 FY. What was the plea offer in this case?
Attempt or no.
The defendant left, said he had, his right had to go. Another case of the defendant treating his felony case as an inconvenient nuisance, then a matter that needed to be addressed. So he left without the court's permission before addressing his case. I'm going to issue a bench warrant for his arrest. 48-hour hold. His bond was $5,000 PR. Now it's $5,000 cash or surety.
Yeah, that wasn't necessarily a good choice on that guy's part. Let's check in with Judge Raquel West, who the other day I kept calling Raquel Welch. I noticed when I listened to the live show later on. It happens. But yeah, let's see what she's got going on.
Yes, ma'am. Let me get it pulled up. Mr. Thomas, in cause number 24, DCCR 2236, you're charged with a third-degree felony offense of unlawful possession of a firearm by a felon. That's from September 11th of 2024. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you actually did what they've charged you with?
Yes.
I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes.
Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you made with the district attorney, you'll be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement that you've reached is for a 10-year term in prison, but that would be probated for 10 years. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes.
And also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Thomas is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that we can get a pre-sentence report done. That'll give me more information about you, your case, and then we'll come back later for sentencing. Ms. Malfino, I know there's some history that's quite old. Is there what's your position on a bond based on the plea agreement?
I would probably feel more comfortable, Judge, if it just remains in custody pending a PSI so the court can approve or disapprove.
I want to make sure that's all the history there is as well. Sometimes there's more. So we'll just get that pre-sentence report done and we'll see you back at sentencing. You can go back with the bailiff. When you come back for sentencing in a few weeks. Nakia Jackson. Mr. Rojas. Mr. Nichols, this is yours. All right, this is an MTRP. Good morning. Are you Nakia Jackson?
Yes, ma'am.
And will your client waive the formal reading of the motion?
She will.
Ms. Jackson, in cause number 19-32344, your charge, I have a first amended motion to revoke your unadjudicated probation. This shows that you were placed on probation September 27th of 2019 for the offense of burglary of a habitation. That was a 10-year deferred probation. Is that correct?
Yes, ma'am.
It alleges that you violated your probation. Count 1 alleges that you failed to report as directed to the probation department for the month of October of 2024. And is that true or not true?
Yes, ma'am, that's true.
Count 2 alleges that you failed to provide verification of performing the community service hours as directed. Is that true or not true?
Yes, ma'am, that's true.
Count 3 alleges that you failed to enroll in the services at the Spindletop Center. Is that true or not true?
Yes, ma'am, that's true.
Count 4 alleges that you did not provide verification of completing the theft prevention class. Is that true or not true?
Yes, ma'am, that's true.
Count 5 alleges that you failed to abstain from the use of any and all intoxicating substances, including alcohol, and that you provided a urine sample August 29th of 2024 that tested positive for methamphetamine and tetrahydrocannabinol. And is that true or not true?
Yes, ma'am, that's true.
Count 6 alleges that you tested positive again on September 26th for tetrahydrocannabinol and cocaine. And is that true or not true?
Yes, ma'am, that's true.
Count 7 alleges that you were behind in your court-assessed fees as of October 29th, 2024 in the amount of $5,636. Is that true or not true?
Yes, ma'am, that's true.
Count 8 alleges that you were arrested for the offense of failure to identify on November 12th, 2024 in Jefferson County, Texas. Is that true or not true?
Yes, ma'am, that's true.
And count 9 alleges that you were arrested for the offense of theft of property on November 12th of 2024 in Jefferson County. And is that true or not true?
Yes, ma'am, that's true.
All right, did you enter your pleas of true to counts 1 through 9 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're all actually true?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Rojas?
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And do you understand if I follow this agreement that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And the agreement that you've reached is for a cap of 8 years in prison, which means we'll come back at a later date and I'll decide your punishment. And if I follow this agreement, I cannot give you more than 8 years.
Yes,
I could give you 8 years, I can give you less. It'll depend on the information that's brought to me at that hearing. Do you understand?
yes, ma'am.
We'll get an updated pre-sentence report done, and Mr. Rojas will present anything to me on your behalf when we come back. State tenders number 1.
No objection.
It's admitted. Any evidence that Ms. Jackson is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your pleas of true to counts 1 through 9 freely and voluntarily. Find those counts true. Find that you're mentally competent and understand the nature and the consequences of those pleas. find sufficient evidence to find you guilty, I'm going to reset your case for sentencing, however, and we'll get that report done. Anything that you think is important for me to know, get that information to Mr. Rojas, and he will present it to me on your behalf when we come back. Okay, you go back with the bailiff. Cap of 8. Mr. Rojas, did you have, that's it for you, right? Okay. Oh, okay, perfect, that's right. Mr. Parker on Jonathan Richard, or Richard?
Yeah, he's one that refused to come see me.
Okay,
If there's any talk to him maybe, or how, no, what's.
okay. Morning.
Let's go back to Judge Fleischer's court, because look who actually decided to show himself, Judge Fleischer. So yeah, maybe he just forgot to turn his camera on earlier, I don't know.
Abigail Balance.
Oh, he should have.
I'll step down.
Yeah, let me go to run the court 8.
So he shows himself and then immediately runs away. Oh, whatever, I suppose. Let's go back to Judge West.
Evaluation report. If they come, you need to cooperate and talk to them. You need to talk to Mr. Parker, okay? You understand? Huh? Yeah, I do need to reset it because you have to talk to your lawyer and I have to make sure that you understand everything that's going on, okay? So you can go back with the bailiff and then we'll get it all figured out. When they come out there to talk to you, you need to talk to them or else we might have to reset it again and we don't want to do that, okay? Go back with the bailiff. What was his name? Y'all playing with me? Y'all, yeah. Is that what the phone number?
What did you write down?
He said, yeah, fine. Well, I want
Okay.
Warren Mills.
Rejection.
Warren Mills.
Everyone is even, I mean,
Mm-hmm.
this is confident. He's doing rejection.
And that one just called us all MFers.
Sincerely. Mr. Smith.
Good morning. Are you Warren Mills?
Good morning, yes, ma'am.
And Mr. Mills, in cause number 25 DCCR 0082, you're charged with the second-degree felony offense of assault on a peace officer. That's from November 19th of 2024. What that means is if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 20 years in prison. Do you understand?
Yeah, I understand that part, yes.
Okay, and I have a plea bargain here on the computer that you've signed with Mr. Parker. This shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for an 8-year term in prison. You have every right to reject that and have your case go to trial and let a jury decide. I just want to make sure you understand what the possible consequences are if you go to trial, and what your options are if you wanted to plea.
Yes, ma'am.
You understand all of that?
I understand.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am. Yes, Your Honor, ma'am. I want to reject it and then I wanted to, see, at that point in time, 'cause I was, you know, I was incompetent at one point.
Okay.
I was out of my mind, which I have a history of it before.
Okay.
Mental health.
Okay.
But I just wanted to say on docket from everybody that in my mind, in my heart, my mind was so I would never hit office.
Well, so
Just the situation that I'm in.
The allegations allege alcohol and drugs.
and is there a video?
That's what I was asking. I wanted to.
Hold on.
Oh, yes,
I didn't see a video on Discovery. There may be, but I don't.
I have
didn't see
a
one.
thumb drive in my file, Your Honor.
Let me do this. So before we move your case to the trial docket, I'm going to let Mr. Parker have some time to get a copy of that video. And then he can come show it to you. You may not remember everything, but maybe that video will help you understand what happened and then see where we get from there, okay?
Thank you.
If you still want to go to trial after you see the video,
Excuse me, ma'am, Your Honor, I really don't want to go to.
well, that's what,
Just kind of.
I want you to see everything. I'll give them some time to get that taken care of. And then when you come back, we'll see what you want to do, whether it's a plea or a trial, okay?
Okay, thank you.
All right, you can go back with the
Can I
bailiff.
ask you one more question? You mind?
Yes, sir.
In a situation of that situation, did probation ever come across the table?
That's between your lawyer and the district attorney's attorney. It's whether or not they offer it.
Okay, thank you.
Okay. I'm just going to delete the rejection. If
Okay.
it's we'll do it again later if that's the case.
Okay.
All right. Samuel Jones, Mr. Parker. I'm for sure being contacted. And you just filled out one rejection on this
They were
one.
going to dismiss the other one.
So real quick, while she's between people, I've got my eyes on multiple different courtrooms at the moment, but everything's kind of a slower pace this morning. So we're just going to stick with Judge West for a while.
And Mr. Jones, in cause number 25 DCCR 0043, you're charged with the second-degree felony offense of burglary of a habitation. That is from November 21st of 2024. Your indictment alleges that you were previously convicted of fraudulent use or possession of identifying information, a second-degree felony, October 20th of 2021. And after that was final, you were convicted of theft of mail, a third-degree felony, December 12th of 2022. What that means is that if you go to trial in this case and you're found guilty, you would be considered a habitual offender, which means your minimum punishment if you're found guilty and those prior offenses are true is 25 years in prison up to 99 years or life. Do you understand?
Mm-hmm.
And I need you to answer yes or no, please.
Yes, yes, Your Honor.
Thank you. And I have here on the computer a plea bargain rejection that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 20-year term in prison. You have every right to reject that and have a jury decide if you're guilty and what your punishment would be if they find you guilty. I just want to make sure you understand what the possible. Okay, I just want to let me finish. I want to make sure you understand your consequences possibly and what your options are.
Mm-hmm.
And you want to reject that offer and have both cases. And so you also have, and let me go through this too, just for the record. In cause number 25 DCCR 0232, you're charged with burglary of a building, a state jail felony. And that is from January 5th of 2025. I'm assuming those same prior offenses are alleged in that one, which means in that case, if you're found guilty and those priors are true, the range of punishment in that case would be between 2 years and up to 20 years. Do you understand?
Yes.
Okay. And you want to reject that offer and have your case set for trial?
Yes.
All right.
And I'd like to indict everybody who have witness. I'd like to indict everybody who caused this case, signed the case.
Okay.
Fingerprints, evidence and everything. I want everything to be
He's complained about some charges that other counties have explained that doesn't have anything to do with here.
So
here, everybody here, and I told him everybody will have to be here at trial whenever.
Yeah, I mean, whatever the district,
Well,
listen.
I want to let you know I'm 17 code. My code is 774 is my badge number. 477 Barras, Bear County, Total Tennessee.
Okay.
Private detective and everything.
Okay.
Private investigator.
All right. So here's what we're gonna do before we move any further with this is I'm going to, Mr. Jones, I'm gonna have someone talk to you to make sure you're competent to stand trial, get all your history, make sure we're all good before we go to trial. When they visit with you at the jail, either in person or on the computer, you need to make sure and cooperate with them, and then we can move your case forward, okay?
Yeah, it'd be fine.
All right, go back with the bailiff, please. So I'm gonna delete that paperwork as well.
So are we not rejecting?
We're not
Because he said he rejects
Nope,
strongly.
yep, nope,
That's my notes on my file.
yeah.
It was fine yesterday.
It's a day. It's a day for
He told me detail about these other cases. I said, look, that doesn't have anything to do with it. And
well,
he's-
we'll see after this.
crazy.
I mean, when you do that, I can't help, I have to. Mr. West, you have Evan Bowden, 2 cases.
Yes, sir.
Good grief. It's, what numbers are you?
They're all joking.
Right? Thank you, Mr. Coleman. That's a
They told me to say you
We're talking about exactly what you did. We're like, she needs to do it. And by the time you started saying it, we're like, yes, that's exactly.
Everybody keeps, y'all just wait, I'm gonna get everybody. All right, are you Evan Bowden? Mr. Bowden, you're charged in each of your cases with evading arrest or detention with the use of a vehicle, and what is the announcement?
Your Honor, this is the case where he also has a pending motion to revoke probation out of Chambers County. I've been trying to work something out with them. The prosecutor handling that case is Eric Carcerano, who's currently in Austin for trying a legislative issue right now. I call it.
This is.
I know, but if I plea him out to this, Your Honor, that's automatic revocation over there, and he's gonna get the back. I know it doesn't affect this court, but it does.
I mean, you've been on the case since June of last year.
I know.
So here's what I'm gonna do. I'm gonna reset it 2 weeks.
Oh, that's fine. Should be fine,
And
yeah.
that is the final reset.
Like I said,
Hold on, it's either going to trial or it's going to get taken care of on that day.
So I'm saying, the offer that the state's made, we want to accept, we like it, it's great. It's just a matter of I don't want to do something here that's going to automatically send him up there.
Well, there's
Once I get
been,
the-
I'm sure he hasn't been in Austin this whole time.
No,
so-
it's just been since
all
our
right.
last resetting.
All right.
So,
You can go back with the bailiff.
yeah, we'll get something done in that amount of time.
Okay, I had something queued up that I wanted to show you guys, and this involves hopping in the Wayback Machine. This actually happened yesterday afternoon in Judge Middleton's court, and it is one of the most bizarre interactions I think I've ever seen him have with somebody. He's got somebody who's being arraigned on a PPO violation, so let's switch over there and take a look at that. Again, this is from yesterday afternoon, but it's not something that we've shown on this channel. So if you haven't seen it, it's quite entertaining.
Hey, Milton.
Good afternoon, Mr. King. I've got Mr. Stickley, the Chief Public Defender, here with me. I got a notice that there's an allegation that you violated your personal protection order. I saw this when I first came in this morning, about 10 after 7. I looked at the roster and I saw you were on it. There was a circuit court matter. Apparently you've already seen Judge Stutzman and he gave you a day in jail and a new date to appear. You also, I'm advised, have a hold on you from Cass County on a fail to appear for what was listed as cyber stalking. So you have a case in Cass County. And
I
then,
called my attorney,
I'm sorry?
and I called my attorney in Cass, and I told him I couldn't make it. Can we
Who's your
reschedule?
attorney in Cass?
I had no fucking idea. He was texting me.
All right,
And I told him-
don't
I
swear.
called him and I told him, I said, I cannot make it to court. I don't have a right. Can we reschedule?
Well, all right, that's their problem and they'll deal with that. my issue is I ordered a restraining order prohibiting you from having contact with Virginia Swanson or going to property at 1307 Briarwood Court, lot 24. And as I recall, this was your brother Dewey's house, and he passed away last October. And there's been a lot of discord since then. Anyway, the allegation is that you did go to that property in violation of my order. So the prosecutor has authorized a violation of a personal protection order. As such, I don't know if they gave you these rights, so I'll give them to you.
So, 25, you have the exact date?
Well, let me find them.
No, wait, Jeffrey, Middleton.
Yes, sir.
I'm your boss, okay? Now, wait a minute, listen. You did not give me no protective period. She did. She put a PPO on me. You didn't. She did.
Yes.
And that is my house. That's in my name. It's in my name, Righteous King. That's what I think
My recollection is it was not in your name. It was in Dewey's name. Oh, here we go. But that's to be determined. At any rate, they requested at least one previous PPO, which I denied because as a rule, you can't use a personal protection order to evict somebody. But there was a separate set of incidents and I authorized the PPO. So you're alleged to have violated that PPO by going to that property and you were prohibited from doing so. You have the following rights. You have the right to be presumed innocent until proven guilty. You have a right to plead guilty or not guilty. At this point, I'm assuming you're going to plead not guilty. You have a right to be tried by a judge without a jury. You have the right to have the assistance of an attorney. So we're going to appoint an attorney to assist you. You have the right to an attorney appointed by the court at a cost of at least $150 or to hire your own attorney if you plead not guilty today. If you have a trial, you have the following rights.
How about this? Hey, wait. How about this? Jeffrey Middleton, as the FBI agent that I am, you're fired.
Okay, well, thanks.
You're
That's
fired.
Great. I wish I was fired.
Because I can't fire you. I can't fire you, and I'm not joking.
You're stuck with me. All right, let me finish this. You have a right to see, hear, and question the witnesses against you at trial. You have the right to call witnesses to testify for you at trial, to have the court order any witnesses you have for your defense to appear at trial, and to be a witness for yourself at trial or to remain silent. You have the right to have the prosecutor be proved beyond a reasonable doubt that you're guilty of criminal contempt or by clear and convincing evidence of civil contempt.
Hey,
you have the right to be heard on bond, which we will address here in a moment. If you plead guilty, let me finish this, Mr. King, then I already have to say. If you plead guilty or no contest, your plea is accepted, you will not have a trial, you will give up the rights that I read to you above. An appeal of right for finding criminal contempt may only be taken within 21 days. If your plea is accepted, any appeal on your conviction and sentence would be by right. Federal law and state law may prohibit you from purchasing, possessing a firearm if you're convicted of criminal contempt. So at this point, Mr. King, do you wish to plead not guilty to the PPO violation?
You're fired.
All right, thanks.
No. I'm FBI agent Righteous King. You know I'm your boss.
You're about an FBI agent like I am. I'm reading Black Mass, which is about the FBI in Boston, which is very interesting. But Mr. King, you're not an FBI agent. You know it and I know it, and you don't have the right to fire me, even though I wish you could. Then somebody else could do this. Anyway, I'm going to show your plea not guilty. I'm going to appoint an attorney. And I'm going to set a PV hearing, a PPO violation hearing.
Boston? I work in Washington DC, dumbass. Not Boston.
The book is in Boston, and don't call me dumbass.
No, FBI headquarters is on Washington, is in Washington DC on Pennsylvania Avenue.
Okay.
Do your math. What? Do your math. Okay? That's where I work at.
Yeah, all right.
Call them.
Now,
call on the phone
Mr.
now.
King.
Call on the phone. Are you scared? Are you scared? You are. You know I work for the FBI.
I don't know why you say this kind of stuff. Mr. King, I'm going to mute your microphone because I don't really care what you have to say. And you're a supreme case of the pot calling the kettle black. Further complicate things, you have a new charge that they're going to arraign you on tomorrow. Prosecutors charged stalking and malicious use of a telephone regarding this Amanda Wilson, who's also the subject of this PPO. And as I mentioned, Cass County has warrants for your arrest too. So I'm going to set your bond here at $5,000 cash or surety. I felt there was a danger to this person. I prohibited you from contacting her. And the allegation is you went to that address. There is a dispute as to who owns this house. And I don't think it's you. So I don't know the date where your hearing is going to be right now. It may depend on who the attorney is. So let's give you one last chance to say something. Do you have anything coherent you wish to say? I can't unmute you from here. All right, Mr. King, I'm going to get an attorney to assist you and we'll set it for a proceeding. As soon as we can do that, you're going to get arraigned tomorrow on your new charge. And either me or the magistrate will see you tomorrow. All right.
Listen to me, please. I'm trying to talk to you, please. I'm trying to be nice to you.
All right.
All right. Who is Amanda Wilson? That's what I'm trying to understand. Who is Amanda Wilson? Who is, you tell me this new charge on this new person, Amanda Wilson?
Well, the first one, the PPO is Virginia Swanson. Amanda Wilson is the subject of the new complaint. Apparently, the allegation is that somebody gave you her number and then you started hassling her. Not sure what this is about, but the complainant in the PPO is Virginia Swanson, who also lives at Briarwood Court. So Amanda Wilson, I don't know who she is either. We'll find out more about her tomorrow. So we'll see you tomorrow. All right, I'm going to appoint Keith Stickley specifically.
Thank you, Your Honor. You have a great day as well.
You're fired. Okay. He's done with circuit court. He's on probation, and these acts would violate his probation. He has a new misdemeanor stalking complaint. He has the PPO violation, and he has a Cass County charge. So there's a lot going on here. All right.
We'll unravel it and get something set tomorrow. You need anything else, or are you good?
No, thank you for checking in. All right.
So I hope you all found that as entertaining as I did. I just got to say, if he's an FBI agent and that's the quality of FBI agents that we have, then perhaps we should take some of this defunding of the FBI a little more seriously. Oh, good heavens. Let's go say hi to Judge Boyd. What do you say?
All right, court is calling 2000,
Not here, Judge.
I'm sorry,
Oh, you got it? My bad, my
Okay.
bad. Sorry.
no problem. Court is calling 2023 CR 2669 State versus Caleb Crum. Can I have parties announced for the record for the state?
Opinion for the state of Texas?
Defense?
Scott Simpson for Mr. Croom.
And are you Mr. Crum?
Yes, ma'am.
All right, did you review the motion to enter adjudication of guilt and revoke community supervision with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Caleb Crum who was placed on deferred adjudication in 2023 CR 2669 for the offense of aggravated assault with a deadly weapon on June 4th, 2024 for a period of 10 years? Is that you?
Yes, Your Honor.
All right, state.
Yes, Your Honor, we're here today on state's motion to enter adjudication of guilt and revoke community supervision. Violation of condition number 30. On or about the 31st day of January 2025 in Bear and or McLennan County, Texas. The defendant, Caleb Crum, did then and there fail to comply with the instructions of Center for Healthcare Services as directed by the head or authorized personnel of that agency, in that the defendant failed to get in compliance with medications in violation of condition number 30.
How do you plead to that? True or not true?
True.
Just 1 second. Excuse me, can I have a stamp for probation, please? Thank you.
State will waive the other violation.
Any objections to the state's waivers?
No, Judge.
Did you understand by pleading true to violation of condition number 30, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 30?
Yes, Your Honor.
Court will find violation of condition number 30 true. Is there a proposed agreement?
There is not, Your Honor. State will make its recommendation. I believe defense will. Well,
All right, state, what are your recommendation?
recommendation is for 6 years in the TD plea, Your Honor.
All right, so you're asking for revocation?
Revocation is 6 years.
All right, in defense, what are you requesting?
Judge, the probation recommendation was not to revoke, but to go to in-state ISF. We understand he needs some type of inpatient treatment. I'm not a huge fan of the ISF. I think the county-run services work better than the state, just from experience. I was asking for the DDRF. His mother is here in the courtroom today. Problem with DDRF is there's a 26-week wait. He still wants to go back to, he was in school at the Texas State Tech College. And so he would like to try to continue with that. I don't think it makes sense to go back to Waco. I think he needs to be with his mom where he has more structure. But he clearly needs more structure. He clearly needs to be, we have a lot of problems with people who have some mental health issues not getting on their beds regularly. And that's an issue. And he understands the seriousness of it. And we're asking it with the court to decide whatever treatment that you think is appropriate.
All right, any objection to the court reviewing the court summary?
No, not from the state.
All right, so let me find it here. Probation. I don't see the attached notes. All right, thank you.
And at the appropriate time, Judge, he wants to speak on his behalf.
Sure. Thank you. Council, did you have a chance to read the notes?
Oh, I've read this.
Oh, and State, did you have a chance to read the notes?
I have not.
If you just give them to the state. Any objections to the court reading that?
No, Judge, and I do, so I do have a letter from that's like the grandfather of the gal he's married to. I do have a letter from her herself.
Okay, all right, and if you'll show that to the state.
I have a.
Sean, you are correct. Allergies are horrible today. I mean, this whole side of me, blockage from allergies. And I don't know, it's only this side.
Really?
Yeah. Whenever my allergies act up, it's just one side.
Should you have those flowers up there next to you?
Oh, the flowers, let me just tell you, they bring me having a bad day. You can look at the flowers and say, there's beauty in this world.
You have a lot. But is that real? That's not real, right?
No. But we can pretend that orchid is real.
What about those?
No.
Those
Deputy, yeah, those are real. Deputy Laura actually put that together.
Okay.
And then this was a gift to me from a student.
It's pretty.
Yeah. And people always think that this one is real, which you think it's real, right?
That's a better view, the way you
Yes.
turned it.
But I've been trying, we're off the record. While he reviews that, I've been trying to find honeysuckle because it reminds me of my grandmother. It's so hard to find honeysuckle.
I've never really seen it in Texas. We had it a lot in New Jersey growing
Mhm.
up, but I've never really seen it here. Must
So
be too dry.
I tell you what, if I have to bring some back with me from Louisiana, I'm gonna take it across state lines.
I
And
think you're
plant
right.
it. You think I'm okay with that?
You're okay. I'll represent you.
All right, if they stop me on the flight, I'm gonna say,
I
Scott
didn't say on a
Simpson.
flight. I thought you were gonna drive it across.
I tell you what, if you're driving from New Jersey, bring some.
Okay.
All right, we're back on the record. So the letters I have were the attachments. And council, you have no objections to my seeing the attachments?
No, and then this is so that's a relative of him and his wife are not gonna, I've talked to the Brooklyn, the wife. And so she got right back to me when I talked to her herself.
All right, and State, you have no objection to me seeing what's purported to be the letter from the wife? All right. Yes.
I have additional notes for your review. These are what appear to be CAD notes from McLennan County regarding the incidents in the letter. I've already turned them to defense counsel.
Any objections?
I'm gonna object to that one, Judge. It's just a reiteration of calls that were made that the grandfather doesn't like him. There's no doubt.
Okay.
And of course, but they don't want to be married anymore. I think that problem's gonna be resolved. Brooklyn does not think he needs to go to prison. The wife herself has a different story than grandpa.
Okay, just one last second. Let me finish reading this.
Grandfather. Her whole family was
All right, so I've reviewed that, and you said there's something you wanted to tell the court?
Yes, Your Honor.
You want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, lower your hand, state your name for the record.
Courtroom.
All right, why are you not doing well on probation?
Your Honor, I moved to Waco, to try to better my life and get, away from the victims that were here and everything else. A little cheaper up there too. And I enrolled in TSTC, or Texas State Technical College, the school. They have a lot of, programs there to help me out and stuff like counseling and medication. I've been trying to look for jobs. They're helping me with that. They're helping me look for an apartment. I'm trying to do my best up there. I was in a really bad relationship with this one girl that her grandfather that the reports on, and I'm trying to get out of that relationship right now. I was living with a buddy. I was gonna report with probation. I think that week, the 18th, I think.
All right, but here's the thing. They're saying that you are not complying with the instructions for Center for Healthcare Services. So I want to know why, and I'm not taking 23 as true because they didn't go on 23, but I'm wondering why you're falling off track with your mental health. That's what I want to get to. I already had told everyone that relationship with the was not going to work.
Yeah.
But you and her, because she came in on your behalf, I want to live. I'm like, this relationship is not going to work. But you all two crazy children wanted to do it. So I'm not even into that relationship part. I want to know why you're not following through on your mental health treatment. That's a problem for the court.
So, the Center for Healthcare, I don't think they have that in Waco, so I was gonna go with TSTC and do it.
Well,
I thought
you're saying you don't think they have it in Waco, but why do you think they don't have it in Waco? Did you report that they give you information?
No, Your Honor, I was just assuming, and I also thought my other attorney had, put in the motion for the Center for Health and ThriveWorks to be transferred up there. So I was gonna go with Texas State Technical College.
No. Let me stop you there. And the reason why I'm stopping you, because you keep getting off track. Condition number 30 states that you did then and there fail to comply with the instructions of Center for Healthcare Services as directed by the head or authorized personnel of that agency, and that the defendant failed to get in compliance with his medication. The fact that you've played true to that tells me that there's a Center for Healthcare Services wherever you were, because otherwise this wouldn't be a violation. They wouldn't have it there. So they're saying that you're not in compliance with your medications and you're not following through on the instructions from Center for Healthcare Services to get in compliance with your medications. Do you understand what I'm saying?
Yes, Your Honor.
So I want to know why you are not following through with instructions for Center for Healthcare Services.
Just misunderstood, Your Honor.
I mean, there's no misunderstanding when they say, hey, you need to get in compliance with your medication. And I'm sure they didn't say you need to get in compliance with your medications. I'm sure it was along the lines of you're not taking your medications. We have reports that you're not taking your medications. You need to get back on your medications, and you didn't do it. That's why you're here.
Yes, Your Honor.
So why are you not being in compliance with your medication?
I have no excuse, Your Honor. And I will accept that I messed up, and I'm wanting, if I can't go back to Waco and finish school.
Oh, you're not going back to Waco. That's off the table.
Okay, and I would like to at least stay with my mom then back down here. I have things lined up ready with,
All right, let me explain something to you, because I'd like for people to know where I am. Number one, if I don't revoke you, you're not leaving custody. You're going straight to DDRF. And DDRF, I know there's a wait time. Now, if you want to discuss that with your attorney, I'm not saying I'm going to do it. I don't know, but those are the only things that I'm considering right now. Either it's going to be revocation or either it's going to be DDRF. So before I even give strong thoughts to DDRF, you may want to talk to your attorney about that because of the wait time.
I understand.
And there's no need to come back to me saying, oh, the wait is too long. You know, can I do this from the outside? Because the answer is going to be no. So I don't know if you discussed that with your attorney.
It's a way better outcome than going to prison, Judge.
Well, I mean,
we've
But you
talked
wanna-
about it back and forth. We're not his mother too wanted to see if she could take custody of him. And so I promised I would make that argument, but I understand where the court's coming from. And I do think the DDRF is a good program. I wish the wait wasn't so long, but that's where we are. And if the court would be willing to do that, my client understands that's still a gift compared to being revoked and going to prison.
Yes, sir.
All right, and I'm not saying I'm gonna do DDRF, but is there anything you would like to add, state? And
Well, I just want to try and re-urge this because Your Honor is reviewing attachments from the court summary, and this is part of the attachments of the court summary. So if Your Honor's going to take a look at everything, we ask that you take a look at this as well.
no objections to the court reviewing that?
I do object, but that's.
No, I mean, if you object to it as hearsay, then I won't review it. What we can do is we can reset this, and if you want to have witnesses by Zoom to address this, that can be done.
I don't think there's a need for that. I just wanted, Your Honor, if over objection. you
I would just ask the court to look at it with some. It's hearsay within hearsay, like, so these are just unsubstantiated reports. And I know the court will look at it critically. That's all I would ask the court, would just don't assume that it's true.
All right. So you have no objections to me taking it, as long as I'm not taking it for the truth of the matter, sir?
Well, you know what I'm getting at.
Yeah. All right, let me review. All right, so this is what I'm going to tell both parties. One, I read all of the hearsay documents. And what I can tell you, do I believe these documents are true? Yes. But I also know that when the grandfather had the police to come out, your wife would not tell them that anything was wrong. And the reason why I believe that she wouldn't tell them is because she doesn't want you to go to prison. And that's what she said. She wants him to get help. She doesn't want him in prison. But do I believe you did everything that's listed in here? Yes. Because all of the evidence point to the fact that you did this. And based upon what I'm reading about her grandfather and your child's great grandfather, because he's the grandfather of your wife, and the child, he's the child's great grandfather. He's concerned about his grandchild and his great granddaughter, and rightfully so. And just so I want you to understand, I understand why he doesn't like you and doesn't want you in their life. Your child, is this a girl or a boy?
It was stepdaughter, Your Honor.
It's on
And it
him.
was a girl.
All right. So,
He
here's
doesn't
the-
have reason for her to just
No.
be with her.
and so here's the thing. I don't know anybody here. Raise your hand if you want your daughter or your granddaughter to be involved with somebody who's on felony probation. I don't know anybody who would be like, oh yeah, sign me up. I want my granddaughter to be with someone who is on probation for aggravated assault with a deadly weapon against a family member. I don't know anybody who wants that. So when people are shocked that a relative doesn't like them, I'm shocked that you're shocked by that. And then you have mental health issues on top of that, and you're not taking care of your mental health issues. And I'm sure you're not bringing in money the way you were supposed to. And he's concerned that you're going to be violent towards his great granddaughter. And I always tell people, children have absolutely zero say so in the foolishness that their parents are out here doing. Like the great granddaughter, his great granddaughter, I'm sure she would say, you know, please, I don't want you to be dating Caleb. I don't want Caleb in this household. But she has no say. You understand?
Yes, Your Honor.
And you've been doing horrible on probation. But I do realize you have mental health issues in state. Let me just explain something. I knew you all want 6 years in prison. He'll be eligible for parole in 3. He's still gonna have the same mental health issues that nobody's going to address. And that's part of the court's issue. So part of the reason why I'm gonna deny the motion is, one, because of what probation is requesting. They're requesting ISF. I don't think this is an ISF issue. I think this is an anger issue. I think this is mental health issue. And I think you're using your mental health issues as a crutch to say, I'm angry because of my mental health issues. I really don't even think that is in any way related to your behavior. But we're going to correct your behavior. And if this correction doesn't take place, you're looking at 20 years in the prison.
Yes, Your Honor.
All right, Ms. Abrams, going to deny the motion, alter in and amend conditions. In custody to the court, he's going to stay in custody until transfer to ISF. I'm sorry, not ISF, DDRF. And upon release, there is going to be full GPS. And counsel, with the full GPS, I'm going to say that the fees, I'm going to ask that the fees be waived.
Thank you, Your Honor.
And if you want it not to be full GPS, you need to come back here and we will craft something
Yes.
that will protect the community.
Thank you, Your Honor.
There's to be no contact with Brooklyn, BROOKLYND from. There's to be, do you have any children? Biological children?
Well, no.
There's to be no contact with minors. And defendant is not allowed in Waco, Texas. So that means if you're driving somewhere, because full GPS is not partial, you better not drive through Waco.
May I add, if I can at least go to Waco to get all my stuff, because all my stuff is still in Waco.
No, that's, you're gonna have a third party do that.
Okay.
Probation, is there anything else he needs? Could you return that to probation, please?
Yes, Judge.
Is there anything else you need from the court to be successful?
Not that I know of, Your Honor.
All right.
He's got a very supportive mother, Judge. She's really nice.
He's not allowed, Mom, he's not allowed in Waco. So, and he is not allowed to have any contact with minors. And he's not gonna be, so that means he can't reside in a home where there are minors. Yes, and he's not to have any contact with Brooklyn, his wife. If it comes time where they're doing divorce in the divorce proceedings.
Right, they are gonna have to do that.
Then just approach the court and we will take care of that.
Right.
Not the divorce, but I'll allow him to, if he's supposed to be in court on
Has
a
to be
specific.
served or whatever.
Yes.
Okay.
Your Honor, if I may ask, how long are we gonna plan for DDRF?
All right, so see, we can go off the record. Let me just explain something to you, what you don't understand. You were looking at 20 years in prison. And because this is an aggravated assault with a deadly weapon, your attorney will tell you, you would have to do 10 years flat before you're eligible.
And he won't
That
get out when
would-
he's first eligible.
No,
Generally, you're
probably
serving
not.
75% of your time.
So here you are, you've just escaped the jaws of the lion. And now you're trying to, how long is DDRF is going to be? Your attorney already told you that. Now, if you would like, because DDRF is going to be a long wait, just let probation know. Don't sign the conditions that I've just set for you. And we will come back quick, fast, and hurry, like today, on another motion to revoke, and I can send you to prison.
No problem. I was just wondering for school.
Oh, school, you're going to have to pick that up another year.
That's fine.
All right. Thank you.
Thank you, Judge. Thank you.
You're welcome.
Okay, let's head over to Judge Fleischer's court.
Terry's the last name?
The state's entering a pre-signed waiver of extradition.
Okay, I'll sign it. Have you advised your client about the pre-signed waiver? Does he know about it? Yeah, okay. Do we need to speak to him or no? No? Okay. Got it. Okay. All right, guys. I'm gonna give this back to you. That's for you. All right, guys, we're gonna start a hearing. We're gonna be on the record. If you want to talk, please go outside. Are you, Ms. Hudson, are you ready on your plea?
Okay.
Got here just in time. This is actually very rare. Judge Fleischer, the majority of his court is not on the record. For him to actually go on the record is uncommon. So let's see what happens here. I have no idea what they're going to do.
Okay. Has he signed his waiver of jury?
I don't recall.
We need to get that done. Huh? Oh, yeah. I see it. Yep, I got it all.
And we do have a stipulation whenever we're ready as to some of the facts, just to.
Sure, of course.
Moving.
You can get some candy on there.
Well, you can't have a hearing without candy. I understand. So, B. Davis, real quick, we're waiting for Judge to come back. We were talking about Lego plants and flowers and stuff like that. If you look behind me, close to the Courtroom Files Live logo there, that is actually a Lego bonsai tree that we built. That's one of my favorite Legos that we have. All right, let's get back to court and wait for Judge to get his candy and start his hearing.
Yeah.
Never heard of them. Well, usually they send them over to the. If you can probably come to count, but. No, we're going to go on further. What do you need?
Apparently, Judge Fleischer had to run to the Circle K for that candy. For anybody who is just joining us, they're going to do a hearing on the record, which is very rare for Judge Fleischer's court. I have no idea what they're going to cover. But just before he was ready to start, he shouted, "I got to get some candy," and then ran away. So we're waiting for him to come back.
Everyone, we are going on the record. If you need to talk, if you need to be on your phone, please go outside. All right, we are on the record in cause number 251-8785. Today is April 1st, 2025. It's approximately 11:03 in the morning. Guys, if I can have you announce yourselves for purposes of the record, starting with the state.
John Davenport, City, Your Honor. Jose Ceja for Mr. Alfaro.
Okay, are you in on this as well?
I'll tell you. Blame jurisdiction on behalf of the state of Texas, Your Honor.
Got it, okay. So for purposes of the record, we are here. Today is set for a dispositive motion to suppress on this DWI second. And we are all in agreement that it is a dispositive nature. So if state loses, you dismiss. If you lose, you end up pleading, correct?
Right, and I think we already have the plea worked out, which is a reduction to DWI first probation.
Okay. And Your Honor, that was a prior deal for the prior prosecutor that I'm honored.
You're okay with it?
I'm honored.
Okay. You said you had some stipulations that you want to go over.
Yes, Mr. Davenport and I have some stipulations regarding to the relevant times, just to speed up the testimony.
Okay.
And I think he's got them written down. I'm not sure if he wants to read them into the record.
You mind?
Yes, Your Honor.
Please.
At 3:40 a.m. on July 7th, the officers arrived on scene. At 3:44 a.m., the officers made contact with the defendant. At 3:46 a.m., the defendant was detained and placed in the officer's vehicle. And at 4:30, Officer Rohr begins the DWI investigation at the station.
You said at the police station.
Yes, Your Honor.
So there's no investigation on the scene.
There is no DWI investigation on the scene.
Okay. So it's your motion.
I don't know if the state is stipulating that this was a warrantless arrest. I mean, if not, then I can just call the officers and establish that.
You don't stipulate that it was a warrantless arrest.
Okay. All right. Ready?
Yes, Your Honor.
Okay.
As
Floor is yours.
witness, the state calls Chad Johnson to the scene.
Do you mind grabbing? Is he in the courtroom or is he outside? Please come up to the stand and raise your right hand to be sworn. You solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God. Okay? Please mind taking a seat. If you don't mind, please speak loudly, clearly. If you hear the word objection, just stop until it's addressed and then you may continue. Okay?
Yes.
Okay. Okay, the floor is yours.
Thank you. Can you please state your full name for the record?
Chad Johnston,
And what do you do for work?
employed by the Pasadena Police Department,
How long have you been doing that for?
6 years.
Do you have any specialized training and experience for that?
That's the police academy.
Can you kind of briefly describe what that training involves?
Police academy?
Yes, just
Penal code, transportation code, CCP, DWIs, traffic stop stack, building clearing. Basically anything that we could use on our government patrol.
And do you have any other experience prior to working at Pasadena Police Department?
In law
In law enforcement, yes.
Yeah.
And approximately how many DWI investigations have you had?
I'm sorry, repeat that.
Approximately how many DWI investigations have you been a part of in your career?
Hundreds.
And do you recall a particular DWI investigation you were a part of on July 7th, 2024?
Sir.
Specifically, how did you come to be involved in the incident we are here for today?
Our dispatch received a call for service while a subject passed out at a intersection on the highway.
And Can you clarify what you mean by passed out?
Subject was inside his vehicle, and then travel, asleep at the driver's wheel.
And what did you see when you got there?
Once I got there, their vehicle in the number 2 lanes for eastbound traffic on Southmore, stopped, driver was slumped over, asleep, with loud music playing from the vehicle.
And what did you do after that?
I waited for an additional unit. Once my second backup unit arrived. He positioned his smart patrol vehicle in front of the suspect vehicle, so if the driver woke up, he wouldn't take his foot off the brake and roll into the intersection that caused a serious crash. Vehicle was on and didn't drive with the defendant's foot on the brake. And then once he was all set in position, we attempted to wake up the driver.
Okay, and how did you go about doing that?
I'm sorry?
How did you go about doing that?
Well, we initially started with flashing our flashlights on him, banging on the window. That was unsuccessful. It got to the point where me and my backup officer began rocking the vehicle for several minutes before, or for a little while before the defendant woke up.
And did these facts at the time, did they indicate or raise your suspicions as to any particular crime that might be occurring?
Possible, yeah.
Why is that?
I mean, normally people do not fall asleep at the wheel while driving a motor vehicle, especially with their foot on the brake and the vehicle still in drive. And then if someone does fall asleep, which has happened in the past, they usually wake up pretty easily and don't need officers rocking the vehicle from side to side in order to wake them up.
So you eventually woke up the defendant, correct?
Yes.
And what did you do after that?
Once I woke him up, he took his foot off the brake and rolled into my backup officer's marked patrol vehicle. Then once he was stopped in the patrol vehicle, he got him to open up the door. I turned the vehicle off and placed it in park, got him outside the vehicle.
And when you got him out of the vehicle, did you notice anything specifically about it?
I smelled a strong odor of alcoholic beverages emitting from his breath in person, and he had slurred speech.
And what did you do next?
I requested a DWI task force officer come to the scene, if one was available.
And those signs that you said you observed when you made contact with the defendant, based on your training experience, what does that indicate to you?
Those are signs of intoxication.
You said you contacted a DWI officer, and after that, what did you do?
He was not available. He was occupied at the jail. Due to the vehicle being in moving line of travel, I arrested the driver for impeding the flow of traffic and transported them to the jail for the traffic offense and for the DWI officer to conduct a DWI investigation.
So you said earlier how many DWI investigations you've been a part of, but how many DWI investigations have you taken all the way through?
Very few, if I were to guess, probably less than 5.
And about how long would you say it takes you to complete a DWI investigation?
It would take me several hours.
And where was the scene in relation to the police station?
Block and a half away.
And how long did it take you to drive from the scene to the police station?
less than 5 minutes.
And can you just clarify, why did you decide to move, again, why did you decide to move the scene to the station?
There are several reasons. One, it's safer to conduct the investigation in a controlled jail than it is to conduct a DWI investigation in the middle of the roadway. Where anyone can come by, get hit or cause an accident, get involved in an accident. Conditions are better, flat, even jail floor as compared to roadways where they're kind of in the ground or anything like that. And then also, our DWI task force officer was occupied already, was unable to make the scene and what did I meet with him at the jail.
Take past the loose, John.
Hold on a second. You said when he got out of the car, he stumbled back or crashed or something?
When he woke up, he took it, the vehicle was in drive with his foot on the brake. So once he woke up from us rocking the vehicle, he took his foot off the brake and rolled into my backup officers.
So it rolled in, it actually crashed into the other car?
Yes.
Okay, all right. That's the only thing I wanted clarification. Okay,
May I proceed?
please.
Good morning, sir.
Morning.
So can you describe in general your role in this investigation?
I was the first officer on scene and I was one of the dispatching and responding officers to it.
Okay, and fair to say that he was in pretty deep sleep, right?
Sure.
And at the scene, very little time was spent with Mr. Alfaro, is that right?
Yes.
Okay, now, you said that you've done approximately 5 DWI investigations?
Yes, but that's what it was, yes.
Okay, but you've done your NHTSA training,
Yes.
and you know that the second stage of the NHTSA training is called the personal contact stage, right?
Mhm.
Do you recall what that is?
I do not.
Okay, you know that in any investigation, it's important to spend time with the person that you're investigating and try to distinguish illegal from legal behavior, right?
Absolutely.
And in kind of big picture terms, that's one of the things that the NHTSA manual teaches you how to do, right?
Mhm.
Is that yes?
Yes.
Because it's not illegal to drink and drive. It's only illegal to drink and drive while you're intoxicated, right?
I'm not necessarily having to drive my belt and container and other violations as well.
Well, we can agree that in not all.
About DWI, then yes, I would agree with you.
Okay. In general, not every time that somebody drinks after having consumed alcohol, not every time are they committing a crime, right?
Correct.
Okay. Now, in this case, you were dealing with somebody who was deep asleep and was roused out of sleep, right? And it wouldn't be surprising if that person exhibited things like red eyes, right?
Yes.
Yes, it would not be surprising.
It would not be surprising.
Okay. That they appeared maybe a little bit disoriented, right? And you say that his speech was slurred, but you had never met Mr. Alfaro before, so you don't know how he normally talks, right?
Yes, sir.
Okay.
I know what slurred speech sounds like.
Okay, but would it surprise you that especially on the station where the audio is more clear, his speech doesn't appear slurred at all?
That would surprise me.
All right. So in the time that you spent with Mr. Alfaro at the scene, that wasn't enough to distinguish whether the symptoms were from alcohol intoxication, possible alcohol intoxication, or just being roused out of a deep sleep, right?
I will not know. That's why I didn't arrest him for DWI right there.
I understand that, but in general, after such a brief amount of time, that wouldn't necessarily be enough to convince yourself that this is just a person that I've woken out of a deep sleep, right?
With other factors, I would disagree, but I mean, there's a possibility.
All right. Did you write an offense report in this case?
I wrote the supplement report.
One moment, Judge. Judge, may I confer with the prosecutor for a second? Okay, your offense report actually doesn't say anything about arresting him for impeding a roadway, does it?
My supplement does.
And Officer Rohrer, who was the lead officer in this case?
Officer Rohrer was the one that worked the DWI investigation.
Okay, and it was his understanding that the scene was being moved to the scene to continue the DWI investigation. Is that right?
Objection, Your Honor, speculation.
If you know.
I don't know what Officer Rohrer put in his report, but I'm not going to tell you what was in his report.
Ask the witness.
Anything further?
Yes, Your Honor, briefly, thank you. Officer, was this a public roadway?
Yes.
And were there any other facts that you said it initially that because of the defendant being asleep, you had suspicion of a DWI potential? Were there any other facts that gave rise to further suspicion of a DWI in the course of your
In my whole encounter?
Yes.
I mean, there was the trauma with alcohol and everything from him. I spoke with him and asked him if he had anything to drink, to which he told me he had a few. So he had admitted to drinking, I could smell it on him, his sort of speech.
State pass the witness, Your Honor.
Nothing further, Jeff.
Someone mentioned something about an open container. Was there an open container or no?
No.
No. Okay, all right. You're excused. Subject to recall, anyone?
Subject to recall, please. Your Honor.
Okay, if you don't mind, please just waiting outside in the jury. Step. Okay, state any other witnesses?
Yes, Your Honor. The state calls Brian Rohr to the stand.
Great. Do you mind grabbing reputation?
All right, where did I stop being sworn in?
All right. Deputy Warden, if you don't mind coming up to the witness stand and raising your right hand.
Sir.
You solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right, please do take a seat. If you don't mind to speak loudly, clearly, if you hear the word objection, just stop until we address it, and then you may continue. Okay? All right. State, please.
Thank you, Your Honor. Can you please state your full name for the record?
Brian Charles Ward,
And what do you do for work?
I'm a police officer,
How long have you been doing that for?
about 4 years now.
And do you have to have any specialized training to do that?
Yes, sir.
Can you briefly describe that training?
The basic police officer's course is about 9 months of specialized training as mandated by TPOL, as well as I'm a member of our DWI task force as well, which is further specialized training.
And what kind of specialized training do you have to have that to be part of that DWI?
We would be part of our DWI task force. You have to have basic SSD, standard skills sobriety tests. You also would highly encourage you to take a ride course, as well as you have to be certified as a drug recognition expert within 1 year of your posting.
And how long have you been a part of the DWI task force specifically?
About 1.5 years.
And over what years, one as a police officer, how many DWI investigations have you been involved with?
I'd say at this point, probably upwards of 150.
And generally speaking, I know everyone's different, but how long does it take you to complete a DWI investigation?
Generally about 2 to 3 hours.
Do you remember, do you recall the incident that we're here for today that occurred on July 7th, 2024?
Yes, I would.
And can you explain how you became involved with that?
With a call service, officers went out, found the reason was people stopped in a roadway. They had reasonable conceit to believe a DWI investigation needed to take place. I couldn't make it out to the scene, so the subject was actually transported up to our in-house room to meet.
And upon contact with the defendant, what did you notice?
I noticed eyes were red, also detected odor of alcoholic beverages and some slurred speech.
And what did you do next?
Next was going into the other DWI investigation, which would be Miranda's questioning and then sobriety tests.
Do you recall the specifics of your investigation as far as the scenarios for sobriety test?
As far as the specifics in clues specifically for the assessing?
Generally, yes. If I were to ask you about the clues that he exhibited, would you recall that?
I would probably have to reference the report again.
So just have one moment, you want? Sure. Let's do it. Mayor Pro Tem Middleton,
Yes.
you recognize, go ahead.
Yes, I do.
Yeah.
It's my original voice from the United States.
Would like to refresh your recollection. Officers, your recollection, refresh?
Yes.
So you made contact with the defendant and you said you began to carry out your investigation.
I'm sorry, say that again.
You made contact with the defendant and you began to carry out your investigation. What was the first step in that process?
So excuse me, I'm sorry. First step of the process would be an interview of the site.
Okay. And what did you learn from that interview? Okay, we're gonna skip that. We're gonna go to the standardized split sobriety test. What was the first standardized split sobriety test you carried out?
Horizontal gaze effectiveness test.
Okay, and what is that test?
That test checks for the involuntary jerking of the eyes.
Okay, and what were the results of that test?
The result on that were 6 out of 6 validated groups.
What are those 6 clues?
The first one is a lack of smooth pursuit. Then following that is a distinct and sustained nystagmus, maximum deviation, and then the onset of nystagmus prior to 45 degrees.
And it's fair to say that he hit all 6 of those clues.
That is correct.
And what does that indicate to you?
That would indicate the presence of a substance in his system.
Can you? Would that indicate alcohol, potential presence of alcohol in the defendant's system?
Yes.
And what did you do next?
Next was the walk and turn test.
Okay. And what is the walk and turn test?
The walk and turn test is one of the psychophysical tests, where it splits the subject's mental and physical capabilities to obviously a intoxicated individual would have difficulty splitting those.
And what were the results of this test that you did?
On this test, I observed 2 out of 8 validated groups.
And what did you do next?
Next was the one leg stand test.
Great. And what is the one leg stand test?
Yeah, it's another psychophysical test. Testing the subject's ability to count while balancing on one leg.
And what were the results of this test?
On this test, I observed 0 of 4 validated groups.
And what did you do after that?
After that would be reading the subject EIC 24.
Based on the totality of the circumstances, were you able to form an opinion on whether or not the defendant was intoxicated?
Based on the totality of circumstances and the results of my investigation, I did form an opinion that he was intoxicated and had lost the mental and physical capabilities required to safely operate a motor.
State best of the witness, Your Honor.
May I proceed, Judge? Good afternoon, sir. Or good morning, I should say. You wrote in your report that Mr. Alfaro was transported to the Pasadena jail for further investigation after he was detained at the scene. Is that right?
That is correct.
Okay, so it was your understanding that he was transported to continue the EWI investigation, correct?
As would my part be investigating, yes, sir.
Okay, he wasn't under arrest for anything else as far as you were aware of?
As far as I know, he was transported, he was placed under arrest for traffic offense.
All right. Now, you mentioned that it takes 2 to 3 hours to complete a DWI investigation. Can you break down exactly what goes into that?
So in those 2 to 3 hours in that estimation, I would be including initial contact of the subject, interview, observation, or possible interview of initiating officer, my interview with the subject, the SFSTs, as well as the collection of a forensic specimen and typing the report.
Okay, but really, when you're talking about an arrest, the relevant portion is usually much shorter than that, right?
That is correct.
So you're talking about maybe the personal contact stage and then the pre-arrest screening stage, right?
I'm sorry, I don't understand the question.
Well, I mean, the point at which you get enough evidence to confirm that somebody's intoxicated or disconfirm that somebody's intoxicated is much, much shorter than 2 to 3 hours, right?
Yes,
Because that takes into account booking procedures and things like that, right?
correct.
Okay. Now, this wasn't a situation where there was an emergency going on, right?
No.
Okay. Even though you're the more experienced officer, Officer Johnson is actually certified to administer field sobriety tests and has done so in the past, correct?
That is correct.
Okay. There wasn't a language barrier or anything like that, right?
Not to my knowledge.
And in fact, the intersection where this all happened, I mean, there were parking lots, drugstore parking lots, places where DWI investigations are sometimes conducted, right?
Yes.
Okay. So, in other words, there was nothing to stop the DWI investigation from being conducted where it was there at the scene of the incident. Nothing that you can point to, is there?
As far as the performance of SFSTs, no.
So what was the reason for moving this investigation to the jail?
To bring him to a member of our DWI task force who is better suited to performance of the SFSTs and to provide a space more conducive to performance of the SFSTs.
Okay, but if you had wanted to, it could have been this, or if, not you personally, but if law enforcement in this case had wanted to, this investigation could have been pursued more diligently.
Objection, Your Honor, speculation.
If there's a lot of sufficient space in a safe place, that again has sufficient space and level ground to perform the SFSTs, i.e. a space and level service more conducive to performing the SFSTs safely, then yes, it can be.
So it could have been done more diligently, correct?
It could have been possibly performed by the officer on scene.
Okay. Pass the witness.
Officer, approximately how long did this investigation take?
This investigation, in terms of interview and arriving at a decision of intoxication, I would say approximately 40 minutes.
And typically, are DWI investigations faster or slower if you or another member of the DWI task force conducts the investigation, rather than a member of the patrol unit?
It is significantly faster.
State passes the witness, Your Honor.
Nothing further, Judge.
All right, witness may be excused. All right, thank you, sir. State anything further?
Just argument, Your Honor.
Okay,
Judge,
so you, hold on. You rest?
Yes, Your Honor, state this.
I'm going to admit a thumb drive with 2 body cameras and then the scene body camera. And I'm not going to publish this right now. I'm going to offer it as a part of the record. And I don't have anything to stick it with, but we can call this Defense Exhibit 1.
Have you seen this? Do you know what it is, State? And do you have any objection?
I mean, it's just body cam from the scene, we bring to Your Honor.
Okay,
Actually,
all right. It'll be admitted. Defense 1?
Defense 1, Judge.
Okay.
And with that, we rest.
Okay. Argument.
Thank you, Your Honor. Your Honor, the state offers 3 arguments here. First is that clearly under the traffic code, Officer Johnson had probable cause to arrest the defendant at the scene for the traffic violation. Upon arrival, the officer could clearly see that the defendant was parked in a moving lane of traffic in violation of traffic code section 545-363 and 545.302. That arrest is clearly authorized under traffic code section 543.001. And after that arrest, once the officer had transported the defendant, then a separate DWI investigation took place, which is clearly legal and proper and does not violate any of the defendant's Fourth Amendment rights. And the alternative, Your Honor, the state would also show that the officer articulated sufficient facts to rise to at least reasonable suspicion that the offense of driving while intoxicated had occurred. The defendant displayed a strong odor of alcoholic beverages, was asleep in his vehicle, and took significant effort to wake up from the officers. Also, the time of night was indicative, and the other facts that the officer suggested, such as slurred speech and the other surrounding circumstances. Furthermore, moving the investigation to the police station and the subsequent time it took to move the investigation. Furthermore, moving the investigation to the police station and the subsequent time it took to move the investigation was reasonable under the circumstances and served a legitimate law enforcement purpose. That purpose was to give the DWI investigation to an officer that would be more efficient at running the investigation. This purpose, this is supported by prior case law in Fleischer v. State, where, Your Honor, the Court of Appeals out of Fort Worth found that a 30 to 35 minute prolongment was reasonable under the circumstances for the express purpose of the officer handing the DWI investigation over to a specific DWI officer for the purpose of efficiency. Furthermore, Your Honor, the state in the alternative to that argument would also go show that probable cause existed at the scene due to the totality of the circumstances and the signs of intoxication and the clear operational facts that the officer had at the scene rose to the level of probable cause for the officer to arrest the defendant for the offense of driving while intoxicated.
All right. Can you come up real quick, Blaze? Come up, Mr. Demo, come up. Sure, on the record. As a lawyer, as a person who just works in general, I really take pride in what we do. You know, when we do stuff, we come prepared. This is not a joke, man. This dude that just came and testified now was a deer in headlights when you asked about the interview. Completely and wholly unprepared in every single way. So I don't give any credence to that testimony right there whatsoever. I mean, it's like, how are you gonna come? This is not a joke. You know, we take this completely serious. You know, you come here, you can't even recite what happened. You can't even take 5 minutes to look at the damn report. You know, really. So that, no credence whatsoever. So what I'm gonna do now is I'll take a look at the facts surrounding what happened on the scene, and I'm gonna make a decision and see whether we go forward or not. But I'm floored how you're just gonna come in and just kind of, here, let me just, you know, really, it's not a joke. It's a life on the line here, and I really take it seriously, and I'm just offended by it. So anyway, I don't need it.
All right.
Let me just take a look. I want to see that real quick, and then I'll have a decision here within a couple hours. Okay?
All right.
All right.
Thank you, Judge.
Thanks.
May we be excused?
Please.
Right.
All right, lawyers, let's go. Just don't, just, it is what it is. You know, it just.
I thought about everything with them verbally. Figure out the condition signed on.
Okay, so he's going to have a decision within a couple of hours. I'm not going to keep streaming for a couple of hours. However, we've already went an hour over, which is fine. Happy to do it, but you know, there are other things that demand my attention as well. And I don't know the judge will stream for another couple of hours. We may not get the answer to this on camera. However, I am capturing the live stream from Judge's Court. I have a computer that is dedicated to that this morning. So we're just going to let it run. And if we get a decision that happens in that courtroom and on camera, I'll bring it to you during tomorrow's live, or if I find out what happens, I'll bring it to you during tomorrow's live. But this may well resolve itself outside of the courtroom and not on camera. So we'll just have to see. Either way, that was wholly interesting, because that's about as close to a trial as you get in Judge Fleischer's court these days. Plus, I found it interesting because during that witness testimony, that's when I commented that he needed more candy and perhaps some caffeine stat, because he acted like he was about falling asleep. But then all of a sudden, out of nowhere at the end, he's like, I'm wholly offended by that witness's preparedness. I'm like, really? I didn't even think you were paying that much attention. So, good on him. So yeah, I'm going to go ahead and leave the show here for today. For all of you who have joined me once again today, thank you so much. I hope you had fun today. It was a little bit of a quieter day in the courtrooms, but we finished on a strong note, so that was good to see. We'll be back tomorrow, Wednesday, 10 a.m. Eastern, 7 a.m. Pacific. Thank you so much. Go